Hello. It's good to see all my viewers out there today. I am attorney Christopher Nudo, and I serve the legal community. Uh, my clientele is based on other professionals and parents and neighborhood folks and just everybody. I like to consider everybody a client of mine, and I work in the field of estate planning, and that includes trusts. And I also do real estate work in the greater Chicago community. We have offices in Elgin, Illinois, and Arlington Heights, Illinois, with the option to meet virtually with our clients from the comfort of your own home. And of course, as traditionally always the case, pre-COVID, and hopefully soon post-COVID, we will all be able to meet together one-on-one. Today, I'm going to be talking about why it is so important to put legal protections in place with regard to incapacity. And many people ask, can you please define incapacity? And there are two types of incapacity. The first one would be a physical incapacity, and that is where you are limited in your ability to do things that you would otherwise do but for the impairment. A good example of that would be somebody who is paralyzed from the waist down, who your disability or incapacity is the inability to walk. Then there's mental incapacity. And this is where you have a cognitive impairment. This is the ability where you cannot function, whether it would be paying bills or having long-term or short-term memory challenges, or many times the most common form of mental incapacity is dementia. And dementia can be defined in many different types of diseases. And I don't claim to be a doctor, so I can't even understand all the variants of dementia, but I will tell you that Alzheimer's is probably the most commonly well-known form of dementia. And so what we're going to be talking about today is how to protect your assets, therefore your estate, while you're alive, should some form of mental incapacity overcome you or one of your loved ones. Now, let me give you a little background about me and why I chose this topic today. Estate planning is much more than just creating a will. Although I will say that most people, when they contact me, don't think of the broader scope of estate planning. They think of just what happens when I die. But a properly designed estate plan offers so many benefits to you even while you're still alive. And then obviously the benefits that come after you've passed to your family. But that is the overall picture of what we describe as an estate plan. Today we're going to be addressing a few areas, and as always, I'm going to save time for questions at the end, so please feel free to load your questions in to the chat area. And I'm going to do my best to get to all the different questions that are asked after I go over today's basic topic. So what we're going to try and get done today is why legal protections for your assets are important and what are those legal protections, unexpected situations that could put your assets at risk, who should be included in your plan. That includes during your lifetime and after you've died. And when should you revise your estate planning documents? And then finally, I think it would be really beneficial if everybody understood what to expect when working with a professional like myself. So um, let's let's start at the beginning. What legal protections can be put in place in the event of incapacity to protect your assets? Well, first let's talk about what incidences can occur that can create these types of incapacity. Depending on your age, incapacity can strike in many different variants. If you're younger, the more common incapacity is going to be as a result of some sudden illness or more likely an accident. We always joke, although it's not all that funny, that one could be walking at any time and get hit by the proverbial bus. And as you can imagine, I don't think anybody really wants to get hit by a bus, but if that ever happened and you did not perish from such an accident, you could be left with some sort of cognitive impairment, some sort of mental incapacity. And this is not based on anybody's age. Obviously, at anybody at any time could have this type of accident occur. And but then as we get older, depending on the conditions in which you live, you're at greater risk for a stroke or some form of dementia to kick in, and of course, as we discussed earlier, Alzheimer's. And so what we want to do is we want to put the first line of defense for tackling these things are powers of attorney. And there's two types of powers of attorney that we want to put in place. And these are very specific powers of attorney. They are called durable. And what makes a power of attorney durable versus not durable? What does that mean? The durability of a power of attorney means that the person whom you're giving the authority to through the power of attorney can act on your behalf even when you have a mental incapacity. So I like examples. If I want to give my brother power of attorney, whether it would be over my assets or over my health care, I would want to give him a durable power of attorney so that in the event I get dementia or I have an accident where I can't think properly and manage my own affairs, my brother can step in and manage those for me. That's true for husband and wives. It is a common misconception that a husband can act on behalf of his wife and that a wife can act on behalf of her husband. But in Illinois, husband and wives are not immediately considered agents for each other. So I always like to put together a durable power of attorney for property. Property, by the way, is equivalent to finances. Commonly, people will say our durable power of attorney for property is also a financial power of attorney. But to my point, which is husband and wives should be agents for each other when putting powers of attorney in place. Now, I said there was two durable powers of attorney. One is power of attorney for property. The other is power of attorney for health care. And as it sounds, a healthcare power of attorney permits you to give authority to a person to make healthcare decisions on your behalf in the event you're not capable of making them yourself. Again, using examples is always the clearest way to articulate this concept. So let's say that I have a stroke and I'm in the hospital, and my wife has my healthcare power of attorney because I granted that to her in a healthcare power of attorney document years before. Now, the doctors look at my wife and they say, there are two types of procedures that can help your husband. One is a surgical procedure, and the other one is a medication procedure. Both have their advantages and disadvantages. And our recommendation is that either one of these may or may not help your husband as a result of the stroke. In that instant, assume that I can't make the decision myself because the stroke has mentally impaired me. This is a good example where my wife would be able to now step in and make the decision that she feels best. Best for our family, best for me, and of course, using all the best information that she knows, not only about our family, but the information that the doctors are providing her. In that same illustration, as you can imagine, bills still need to get paid at our house, and the finances need to be moved around, and maybe we need to liquidate some of our investments to keep things current if my income cannot continue to come in. And she's going to need the ability to manage all of this. And under my example, let's assume on a day-to-day basis, I manage these things. Well, as long as I've prepared a power of attorney for property, aka a power of attorney for finances, and it's a durable one, now my wife can step in and she has all the authority necessary to manage the finances, liquidate some of the assets, and do what's necessary to ensure that our home and all that's related to it is upkept properly. So it's just way too common that I get a phone call where somebody has dementia or has had an accident, and people are asking me, Chris, can we put these powers of attorney for healthcare and property in place now? And unfortunately, the answer is no. It's too late. One must have proper capacity, meaning no cognitive impairment, to actually grant a power of attorney. I strongly believe, and this may surprise some of you, but I believe as soon as a person turns 18 years old, they should prepare a power of attorney for healthcare and a power of attorney for property. And in, I would say, 99% of the instances, that authority would be given then to their parents. 18, 19, 20-year-olds, they're subject to accidents no different than people who are 75, 76, 77, 80 years old, and everybody in between. So when you don't know when the unexpected is gonna hit, that's why it's called unexpected. So I always tell people, prepare while you're healthy so that when the unexpected occurs, you're protected. So there's also one other instant that I think is important. And we talked about accidents, we talked about death, but there's also lawsuits that can take place. And I always say that with having proper estate planning done, in certain instances, It can protect your assets from judgments or any other claim that might come against your estate as a result of a lawsuit. Now, I don't want to take that statement too far because in Illinois, we do not have what's called an asset protection statute. We cannot take our assets, place them within a vehicle that we own, and protect it from our creditors. That's not permitted. There are states like Nevada and Alaska and a couple others that have such asset protection statutes. However, Illinois is not one of them. However, with a well-designed estate plan, there are certain instances, certain steps that we can take using husband and wife's individual trusts in which to create some small form of asset protection. So, who should be included in an estate plan? Well, obviously, husbands, you should include your wives, and wives, you should include your husbands. After that, estate plans and who should be included, a lot depends on your family dynamics. Do you have children? If you do, how old are they? Do you have parents? If you do, how old are they? Do you have siblings, brothers, sisters? How about nieces and nephews? How about those best friends of yours? It's remarkable to me over the years how you have friends that are closer in value and in genuine closeness relationally than many family members. Just because family is family doesn't mean that they're always your best choice to include in your estate plans. Very often, friends who share similar values are a better choice in your estate plan. Children, if they are old enough and they are uphold the same value system that you do, should be included in your estate plan. Why do I keep focusing on this value proposition? Well, it's my belief that everybody who puts an estate plan together is representing an extension of themselves when they no longer can represent yourself. And there's two instances in which you can't represent yourself. The first is when you become incapacitated. The second is when you die. And so I believe that if an estate plan is nothing more than an extension of who you are and how you want to end or final disposition of who you are and all you represented on this earth from an asset standpoint, then who best to share in that experience, whether it would be at the administrative level or the distribution level, but people in your life that share the same values. When should you revise your estate planning documents? Now, if you follow me on a regular basis, you know that I cover this topic often. I believe our offices are firm believers in that your estate planning documents should be reviewed upon a life event. It's not necessarily how much time has gone by, although times can create life events. For example, I do my estate plan when my children are 3 and 5 years old. When my children graduate college, that is a life event. If my marriage should fail and I get a divorce, that's a life event. If I should have more children, while that's not necessarily a life event, I think most people would include expanding your family being a life event. Another life event would be if I got remarried and if my new spouse had children. Another life event would be if the people that I have put in charge as guardians of my children, or as successor trustees of my trust, or as executors of my will, or agents of my power of attorney, I think you're starting to get the point here, no longer are qualified to do the job. And you might ask, well, why wouldn't they be qualified to do the job? Well, number one, they could die before us. Number two, they could have some form of incapacity themselves. Or number three, you know what? They just may not be our friends anymore. And so those are life events. Now, I've just outlined a few examples, but I like to say that anything that would change how you want your estate handled when you die would be considered a life event. Many older people consider the birth of grandchildren to be life events because they want to include very specifically their grandchildren in their estate plans. So, in summary, when should we revise our estate plans? Upon a life event. Now, if you want something a little more concrete than that, I tell people to look at their estate plan every 3 to 5 years, but not every 3 to 5 years in the context of updating their plan, but every 3 to 5 years as to whether or not a life event has occurred in which their plan should be updated. What should you expect when you're working with an estate planning attorney such as myself? Well, you should expect some very difficult questions. And we don't ask these questions to trouble you. We ask these questions because we're trying to take your life, your family dynamics, your assets, and we're trying to help direct you into the most comprehensive plan that will help you in the event of some form of incapacity or when you die. You're going to be asked some very difficult questions like, if you have minor children, who would raise those minor children if you and your spouse were no longer alive? Other difficult questions. Who would manage the money to raise the children? Who's going to manage the money to distribute the money to whomever it needs to go to? Who is going to make healthcare decisions on your behalf if your spouse cannot do it and you become incapacitated? Who's going to help you pay your bills in the event that you don't have a spouse because they've predeceased you or you're not married and you need help managing your finances? Most people find these to be very difficult questions that they must sit and think through and come up with a decision that gives them a great deal of comfort that they're choosing the right people. Now, here's a question that I get asked a lot. Should I first ask these people if they want to do this job before I name them in the documents? My general answer is no. I typically believe that people don't know if they're willing to be guardians of your minor children, or if they're willing to help you in a healthcare crisis, or whether they're willing to help you manage your money if you get dementia, or whether they're willing to administer your estate in the event you die. They don't know whether or not they're really up for that task. until the time that it occurs. Now, some people are going to absolutely rise in the moment and they are going to be ready. And we don't know if they would have accepted the position or not accepted the position if you would have asked them that question prior to the event occurring. Now, not everybody's going to rise to the event. So, I suppose it's rise to the occasion. That sounds much better. Anyway, moving on. That is why we put multiple people in succession so that if one person is not capable of doing the task, either because they're not capable or they choose not to, or whatever the case may be, we have backups. And I always think that the best backup scenario are 3 people. So you have your first choice, your second choice, and then your third choice. So let's pause for a minute here and do a little recap. For those of you who are just joining us, my name is Christopher Nudo. I'm the founding partner of an estate planning practice that serves the greater Chicagoland area. We have offices in Arlington Heights and Elgin, Illinois. I serve the local community, and I just like to say it's everybody, from the policeman to the firefighter to the doctor to the nurses to the factory workers to other lawyers. Literally everybody is my client. Even pastors and nuns and just everybody. I consider myself a Christ follower, and you can read more about my faith and my testimony on my website. But my job is really to serve the greater community in helping plan for death and incapacity. And we call that an estate plan. And that estate plan is designed to really perpetuate and protect your legacy. In this week's program, I've described what happens in the event of an incapacity and how to deal with incapacity issues, both at a healthcare and a financial standpoint. Also, if you missed my last session, you can watch it right here on Facebook, or you can get it off of my website. And I explained what goals should an estate plan ideally accomplish. It's a really great overview for anybody who's unfamiliar with the benefits that an estate plan can provide. You're welcome to join us here every Friday at 10:30 a.m. That's Central Time, where we share tips and legal guidance for parents, guardians, and other professionals. All right, as promised, I did save time for questions, and I see that we do have several really good questions that came in. So let's just get to it right away. Okay, let's see how many of these we can get through in the time that we have allotted. Question number 1. Do I need to get my assets appraised or assessed to protect the value legally? The answer is not necessarily. So if you have a very valuable collection of something, I do recommend having it appraised so that your estate has some appreciation for the asset that they're managing. And if you die and they need to sell that asset, they have a baseline in which to work with. For sure, there are in high value taxable, federal estate taxable and state taxable situations, instances where having an appraisal of an asset is very valuable from tax points. But I believe that if you have a very valuable collection, whether it's your frog collection or stamp collection, baseball cards as examples, and you have it appraised, what you're doing is you're really helping the people that you've set in place to administer your estate so they can do the absolute best job in recognizing the value of this very special asset that you've put together. Second question that came in is, how can I prevent my family from selling everything if I'm unresponsive? Now, that's a very excellent question. And I want to caution my answer here with sometimes selling all of your possessions may be in your best interest. And I know that that flies in the face of some of you who are like, I don't want people to take my assets. But remember, what are your assets? They're nothing more than a representation of your stuff. And your assets can be financial and they can also be tangible property. Some people have some really valuable tangible property that if you're alive and you need care, and sometimes your assets just need to be sold to provide you the proper care that you have earned and you deserve. Now, I think the question really begs a little bit more expanding on the term unresponsive. If you are in some form of medical state and the doctors are unsure the likelihood of your recovery, then I think it's in your best interest that the people that you've put in charge of your estate use the assets that God has given you for your best care. And should you recover and your assets all been used for your best care, well, I know that will be in some instances disappointing to some. I do believe that as long as your best interest was considered when these assets were liquidated, that the people that have administrated your estate have done the best job. The only thing we don't want is some sort of waste. And the laws in Illinois protect your estate from your healthcare, or really it's your financial power of attorney or your successor trustee under your trust wasting your assets. And a waste of an asset would be the spending or the liquidation of an asset that didn't prove to be, in any sense of the word, reasonable as for your best care. Let's see, our next question. If I'm unresponsive, here we go with the unresponsive again. Again, it's going to really depend on the definition of unresponsive. But if I'm unresponsive, what are the typical time limits people should include in healthcare directives? Again, in Illinois, under our healthcare directives, we don't specify time frames. And it's really going to depend on the degree of unresponsiveness. What we like to do is we set guidelines. And what we say is we base it on people either value quality of life or they value length of life. If you are a quality of life person, what you're saying is to your healthcare power of attorney agent, I value my quality of life over my length of life. Meaning, if I can't maintain a quality of life in a way that is similar to what I had become accustomed to before this unresponsiveness took place, then make your decisions based on what's best for me. So in some instances, dying may improve my quality of life over staying alive and being in an unresponsive state. Now, other people take the complete opposite approach. They say, you know what? As long as I'm alive, that's quality. And so staying alive to me is far more important, no matter how much it costs my estate, no matter how sick I am, no matter how poor my lifestyle has degraded as a result of the accident or illness. Staying alive is the most important factor. And these are the benchmarks that we will help you decide on, that you will give these instructions to your healthcare power of attorney. And I would say in Illinois, these are the best answers to that question. Good question, though. All right, what do we have next? I have minor children. What can I do to protect them if, interesting question. I didn't read the whole thing because it's written a little funky. It says here, the question is, I want to care for my minor children, and what happens if I become incapacitated? And that's an excellent question. In Illinois, we have temporary guardianship. And while what I'm going to say is not an absolute, what I would say is the best thing you can do for your minor children is to set up a living trust, have a healthcare power of attorney, and a durable power of attorney for property, and to designate similar people to work in those capacities as successor trustee and as agent under those powers of attorney. And through those 3 documents, there will be sufficient authority to manage your minor children and their upbringing during your period of incapacity. Now, if there's no living parent and you're completely incapacitated with no chance of coming out of that incapacity, then guardianship for your children might be necessary. But for purposes of this question, I want to say, if you do a proper plan as outlined, it'll get you a long way to helping those minor children. And then let's hope that your incapacity is not something permanent, but something temporary. In those instances, having a plan like this will be able to have people help you through this temporary state of incapacity. Next question is, if I'm a business owner, what can I do to protect my business in the event I'm incapacitated? Well, this is beyond the topic of today's discussion, but it's an excellent question, and I'm going to start with something that might surprise you, and that's going to be life insurance. And you're like, but I'm still alive. We're talking about if I'm incapacitated. Well, another form of insurance is called disability insurance. And I know I kind of jumped outside the realm of the typical estate planning documents, but I strongly believe that disability insurance and life insurance can protect your family in the event of the unexpected. Let's use it in the context of this question. You're a business owner and you're the engine, if you would, that pulls the train for not only your family, but for many employees. If you become incapacitated and no longer can pull that train, you're going to need a source of income. And this is where disability insurance comes in. And so if you own your own business and you're the train, you're the engine that pulls that train, I strongly recommend that you look into disability insurance. In the same context, if you should die unexpectedly, That's where the life insurance fills that same gap. Um, so we got this question last week too. I find it very interesting. It must be on a lot of people's minds. And it's, what's the difference in the way you plan your estate plan if you're an entrepreneur versus if you work in a corporate job? I think what's really being asked here is, are there different levels of risk, which then produce different levels of planning based on if you're the type that owns many little businesses or you're the serial entrepreneur kind of person versus you have the 9 to 5 dependable W-2 type of job? The answer is um, uh, the answer is very complicated, actually, as my brain just started to spin that up. But what I would say is the serial entrepreneur who has his hands in has many irons in many fires, it's going to be more complicated and it's going to require more thought to ensure that each one of their thoughts, concepts, business entities, etc., are in the estate plan and are contemplated and thought through very thoroughly to make sure that each one of those irons is dealt with, versus the person who works in the singular corporate job that pulls down a single income. That person, we're not as much focused on all the different irons out there, but we're more focused on extending their value system after they die. And so the planning is actually very similar. It's just near the end of the planning, one becomes more complicated than the other. The serial entrepreneur is going to have more that needs to be thought through. But at the end of the day, the goal is that whether you are an entrepreneur with many businesses or whether you have the 9 to 5 corporate job, that your assets, your estate goes to the people who you want them to go to in the manner you want it to go to after you die. And in the event of incapacity, through some form of cognitive impairment, dementia, Alzheimer's, etc., that your estate and its assets can be properly administered for your best interest and your family's best interest. What would happen if you created these documents incorrectly? Say a will. You know, it's very common for people to ask, can I produce these documents myself? I often hear the comment, Chris, you're just filling out forms. Can't I find the form on the internet and do it myself and save all this money? And the answer is, I believe everybody should have the ability to do whatever they want. We live in a free country, and you can pretty much, Google has provided virtually everything available on the internet. Here's the problem, and here's the reason why I strongly do not believe in do-it-yourself estate planning. Estate planning documents are extremely nuanced. They have not only a lot of very technical detail within the documents themselves, but also the way they are executed is very nuanced, very detailed, very specific. And if it is done incorrectly, then it can void the entire document. For instance, in Illinois, if a will doesn't have the proper initials and the proper signature with witnesses and notary and the proper attestation language, then you run the risk of having your will voided. If you have stray markings on a will, like you tried to amend it with a little strike it out initial kind of thing, you could potentially be voiding your will. And that's true for powers of attorney, for healthcare, and for finances, and your living trust. Well, the the details and nuances of the execution process are different from document to document. What is true is that if done incorrectly, you could strongly be risking voiding the document and making the document worthless. Wait, sorry, skipped one. If I have a limited budget, what documents should I have prepared first? I would say this. If you're married, then you should do a will and a power of attorney for property. Those, I believe, would be the first two documents that are if you're on a limited budget. If you're not married, I believe you should do a will, a power of attorney for healthcare, and a power of attorney for property. Those would be the limited budget documents. Those don't always mean that your estate is well-rounded and prepared perfectly for all instances, but in a limited budget situation, that's the order in which I would recommend documents are prepared. Do I offer virtual appointments or on-site visits? Well, yes, to both. I use Microsoft Teams most often for my virtual appointments, and you'd be catching me on my computer just like this, and I have all the tools in which to use pictures and describe everything that needs to be described, no different than if we were in person. Feel free to schedule an online video consultation or a in-person visit if you would like to know more specifically for you and your family regarding estate planning. Where can I contact you to set up a consultation? Well, at the bottom of this screen, we'll have my phone number, email, website, and that information. It wouldn't surprise me if it pops up just like that. Oh, and you can text me, looky there. So follow this information at the bottom of the picture, and it can take you to where you can find more information. Well, listen, this has been a ton of fun. I hope it's been as interesting for you as it is for me. I always say that the teacher always gets the most out of the lecture. I really appreciate all the extremely thoughtful questions that came in. I cherish the opportunity to even have the ability to spend this time with you and earn your trust so that in the future, I can be of service to you and your family and to secure your legacy going forward. Like anything in life, proper estate planning is a process. It takes some time, and I encourage you to reach out and start the discussion with my office now. It would be my pleasure to discuss your family's goals and values, and so that we can put the right plan in place for yourself. I invite you to join me here again next week, Fridays, 10:30 Central Time. Please feel free to invite your friends. I don't think I'm all that scary, so your friends might enjoy learning the little bit that I have to share over the brief time that we have to share. And feel free to share the recordings with your family members, colleagues, friends. Hope to see you again next week. This has been Christopher Nudo with Estate Planning. Have a great day.